Hello, everybody. I'm Philburt, President and CEO of AIM Employers Association, and welcome to This Week at Work.
Welcome to the only show about the workplace that offers you front row seats and a microphone, bringing you practical, timely, and accurate insight so that you can more effectively lead your organization. It's Thursday, December 8th, episode 208. Today, bad documentation kills. Good employment documentation can help you, but bad documentation can end you. Phil and Burt are here for you, offering tips and tricks to cover your assets. And is it game over for Microsoft? Gaming workers formed their first ever union in the U.S., seeking fair treatment, transparency, and a voice in workload decisions. As always, we'll cover all the breaking news you need to know and have fun doing it. Speak up, take the poll, and ask your questions. All this and more on This Week at Work.
All right, great to have you all with us once again. Welcome back, Burt Garland, shareholder with Ogletree Deacons. Glad to have you with us, Burt. There is a lot going on across the world today between the World Cup and the holidays, parties, business year ends closing. There is just more than I can handle. I don't know about you, but I have been enjoying some World Cup soccer. I'm sorry to see the USA team drop out, but I still have a couple of favorites in that I'm pulling for. How about yourself?
Unfortunately, I haven't had much time to watch too much of the World Cup these days, Phil. I've been hard at work.
All right. I'd like to hear from some of our listeners and who they're pulling for as it comes to that. I'm still pulling for England. That'll be the team. Of course, most people who know me know I lived there and it was easy to become a fan. They're a great country for soccer. And so I hope they go all the way. I think they got as good a chance as anyone, but you always have Brazil out there who's a big threat. Let's get on with the poll question for this week. We'd like to hear from you as it relates to that. What is your biggest challenge with employee documentation, retention, security, standardization, accuracy, compliance, people resources, whatever it is? We'd like to hear from you. If you get a chance, leave us some comments in the chat as well about that. And Burt, the other thing I just want to mention before we get to Lawyer on the Clock is that our Right to Weed program that you, myself, and Officer Tyler Jenkins from the Missouri State Highway Patrol are going to be hosting. That program, as soon as it opened for registration, it sold out in person. It was almost like a rock show concert. It was awesome. We have over 130 people attending virtually by simulcast. It's going to be a very good program. There's still time to register. You can visit the AIM website if you're interested in joining that program and understanding some of the challenges that we're facing as employers, particularly now in the state of Missouri, where we are officially a right to weed state. Okay, Burt, are you ready for Lawyer on the Clock?
Let's do it, Phil.
All right, here we go. Roll it, Nick.
All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So, Phil, you stole a little bit of my thunder, but of course, today is Missouri's official entry to becoming a right to weed state. We officially go green today. And what that means is that anyone 21 and older without a medical marijuana card will able to buy weed for recreational use. But I want to caution people, they can't just walk into a dispensary and purchase marijuana, at least not yet. The dispensaries themselves actually have to submit a letter to the state of Missouri, the Missouri Department of Health, saying that they want to have what's called a comprehensive license versus just a medical license. And that means that once they submit the letter, they have to prove that they have no violations, that they're in good standing with their license, and that they pay their dues. And then the Missouri Department of Health has 60 days from December 8th to approve each request. So we're sort of dependent on the Missouri Department of Health.
February 8th, possibly somewhere in that time frame.
Could be for some dispensaries. My hunch is that some of them will be ready to go today, though. We'll see.
I assume it'll be a rubber stamp for most of them. Hope, and we'll see how long the lines are. That'll be the interesting bit. I'm sure it will be on the news. The first recreational buyer in the state, all those things that you're used to seeing when something like this happens in one of our neighboring states.
Yep, very good. Next, Phil, I want to move on to talk about a very significant decision out of the federal courts in Texas. In Texas, there was a verdict in July of this year that said Southwest Airlines needed to pay $4.15 million in back pay, pain and suffering, and other costs to a plaintiff, and the union representing the employee was also ordered to pay another $1.15 million in a lawsuit that involved the employee's religious expressions. The case was then submitted after the jury verdict to a judge, a federal court judge, who issued an order saying that Southwest Airlines must reinstate the former flight attendant who claimed the airline and the union violated her rights by firing her after she sent confrontational anti-abortion messages to the union's former president. So after the verdict, the case was submitted to a judge. The judge reduced the verdict from $5.3 million in damages to $810,180, including $150,000 in back pay, because the federal law limits the amount of damages that can actually be awarded. But the court did enjoin the defendants, the union and Southwest Airlines, excuse me, from violating employees' religious practices and beliefs. The plaintiff in the case was fired in March 2017 after she sent confrontational emails and social media messages to a former flight attendant union president. The employee called the former flight attendant union president despicable for attending the Women's March in Washington, D.C. earlier that year. She had said, quote, "This is what you support during your paid leave with others at the Women's March in D.C. You truly are despicable." She cited that she shouldn't be attending anything where Planned Parenthood was involved or any entity that supports abortion rights. Now, what's interesting is, she was pretty direct with her communications, but it was based on her religious beliefs. And what's interesting here, people have heard me on the program before encouraging companies themselves to try to stay neutral in these types of debates. Companies themselves are nothing but fictional legal entities, and they're made up of their people, and they act through their people. And what this case demonstrates is that the religious freedoms, just because you may advocate or you may be pro-abortion, it doesn't mean necessarily that your pro-abortion or your pro-abortion stance is going to outweigh somebody's religious beliefs. And so my speculation,
That's a very interesting case. I mean, because it sounds like she was very aggressive in her communication, which understand the aggressiveness would not be welcomed by anyone, just by the nature of being aggressive. Do you know, did she use company resources for any of that communication?
That I don't know if she used company resources or not. I'm assuming maybe she did because it was in an email, but I'm not quite sure. The Southwest Airlines did say it's going to appeal. I imagine the union's also going to appeal. But what this illustrates, and I want to shift gears slightly and talk about what's going on at the U.S. Supreme Court this week. This week, the justices on Monday heard oral argument in a case called 303 Creative versus Alenis. And that's a case involving a Colorado website designer who says her state's anti-discrimination law would compel her to create speech that contravenes her Christian beliefs. So again, this is a U.S. Supreme Court case. The Southwest Airlines case is just one case from a district court down in Texas, but it does show the significant financial risk of a company taking a position against an employee's religious beliefs. In this particular case, the individual, the plaintiff in the case was somebody wanted her to create a website for an LGBTQ wedding. In this individual, once she started her business, she expanded her portfolio to design custom wedding websites that celebrate marriage between husband and wife. But her home state, according to her, made it clear that she's not welcome in that space. She says the state is trying to force her to create custom artwork and promote ideas inconsistent with her faith. Now, you may recall that coming out of Colorado several years before was the case of a baker who did not want to bake a cake for an LGBT couple, and that case garnered quite a bit of attention. The individual in that case did actually go all the way up to the Supreme Court. Now, the reason I'm talking about these cases is because it does point out a very, very difficult issue. And again, unless you want to be activist in one of these spaces and become a test case for one of these cases, my suggestion is that you kind of remain neutral to the extent possible. I know that being neutral is not acceptable to some people, but when you're advocating for a company that consists of people with all kinds of views, my suggestion is to try to be neutral on it. Justice Sotomayor asked a really important question during the case to Colorado's Solicitor General, and she said, and this is where I think the analysis gets really difficult. She said, if we ruled in favor of the business of the website designer, this would be the first time in the court's history that it would say that a business open to the public could refuse to serve a customer based on race, sex, religion, or sexual orientation, correct? And the Colorado solicitor answered yes. So the difficulty there is balancing religious freedom on an LGBTQ issue against the LGBTQ rights. As the Supreme Court has already said, LGBTQ, sexual orientation, gender identity is protected under Title VII of the Civil Rights Act. If you extrapolate this a little bit further, what happens if a business says, based on my religious views, I don't want to serve Blacks, I don't want to serve Jews, I don't want to serve, make up whatever category you want to make up. And so when at some point does the religious view become too extreme that it conflicts with the other laws in the United States? And I think we're looking for guidance from the Supreme Court on this, and hopefully we get a decision that makes it a little bit easier for employers to operate in this space.
Yeah, that's both of those are quite interesting cases. I can see each side of those stories and how they're trying to move or have their rights protected, and how the law is taking a position one way or the other. I really find the case with Southwest Airlines and the union quite interesting, because the employee is going after both the union and the airline. I'm assuming the union did not represent the employee the way the employee felt should be represented.
Yeah, that's correct. And so basically against Southwest, it was what's called a duty of fair representation case. And against the union, it was duty of fair representation. And against Southwest, it was, and the union was for discrimination.
Yeah, fantastic.
So there's a great question. Is there a distinction between essential products and services versus not? And yes, that's a question from Angie. I think it really does depend on that. I think that's where the space may be, where the court really focuses their decision. And in fact, Justice Clarence Thomas did sort of get to that when he was asking questions in the case that kind of really tackled that issue. He said that he was looking at it and interested in the case because there's a lot of other places that somebody could go to get this done. It's not like it's a hospital or something like that. So again, I'm not going to get too far into the weeds on it. We'll wait for the Supreme Court to issue its decision. But I do think that this decision this week is going to have very profound impact.
Yeah, absolutely. That makes me want to tune in next week and hear the outcome of that.
Oh, it's not going to be next week, Phil. They're going to take months to rule on this one.
Okay, well, when it happens, we'll be here with the results. I think we need to keep moving on here, Burt. You've heard it right there from our region's best, Burt Garland. That's a great update. Those are really practical for us to use. We deal with these types of scenarios in the workplace all the time. I can't tell you how many times employers call and they have these types of challenges. You have to seek advice. You have to tread carefully. They can be managed and managed away, done correctly, but they can really cause you a lot of problems, as we can see what's happening with Southwest. And you have to assume Southwest had all the best advice making those decisions. All right, let's move on. Nick, can we take a look at the poll results that we have this far? Okay, so it looks like standardization seems to be one of the biggest challenges. I would have anticipated that, followed by accuracy. There might be a similarity between accuracy and standardization as well in the way it's being interpreted. We'll keep that in mind, Burt, as we talk about performance management systems and the advantages and disadvantages of those here in a minute. But before we do that, let's warm up with a little Philburt's Forum.
You've just entered Philburt's Forum, where we peel the onion back, a lighter look at the workplace.
All right, Burt, I want to talk a little bit about the code, and that's, our listeners are certainly aware of it. The code we use when performance reviews occur, when we describe a trait of an employee or colleague, and that other people then will work to decipher. And I know we have some examples of what we mean by the code. What do we have here, producer Nick? Someone who's meticulous attention to detail. We all know those people. What might we call them under the code? A nitpicker, right? Absolutely. We know nitpickers. I've even seen people write nitpicker down before in a performance appraisal and say, they just nitpick every little attention to detail. And at the same time, I've had people say, you need to be more attentive to detail as well. Any other ones here, Nick? Actively social. This is a good one. That person may be under the code, gets phrased or dinged as drinks a lot. We know they're very actively social at the holiday party. Quick thinking. When we look at the code there, offers plausible excuses. They're kind of hard to pin down. We got more of them. Careful thinker. When we think about that, they won't make a decision. I got some other ones I want to add to that one, Nick. Just hold it there for a minute. When I think of like a careful thinker, I also think about someone that is maybe they won't make a decision. They're slow to make a decision. They're also not engaged. They're also sometimes referred to as a perfectionist. The list goes on and on. Let's look at a couple more here. Uses logic on different jobs, get someone else
difficult
to do
jobs,
it.
Phil.
Difficult jobs, excuse me. A little bit of a Tom Sawyer right there, huh? And Huck Finn.
Absolutely.
With that one.
You're sure good at painting fences.
That's right. And has leadership qualities, is tall or has a loud voice. All right, good communication skills, spends a lot of time on the phone, loyal, they can't get a job anywhere else. That's what we think of. But I tell you what, today we would appreciate people who are loyal. And then a valuable resource is bills in 6-minute increments, commonly says, it depends, name the one and only Burt Garland.
A valuable and expensive resource. Sorry, I hate billing in 6-minute increments. It sucks.
But nevertheless, Burt, you are invaluable. And I think that that just goes back from the holiday party that we had and the compliments we got. I know they were in the dozens by our attendees for your time and commitment to the program. I hope you got them as well in person, but great job. And you are, in my opinion, an invaluable resource to our members and your clients. And I hope we continue that throughout 2023.
Yep. Moving on to year, year we've been 2020, 2021, now 2022, and heading into 2023 with the program.
Absolutely fantastic. All right. So Burt, let's move on and let's talk a little bit about performance reviews and what we're up against. And I know we have some slides you want to go through, and I'm going to turn it over to you and let's get talking through a few of these slides here.
Yeah, I appreciate that. So, Nick, I'll ask you to put up a few slides here. And Phil, we're going to be a little bit broader than just performance reviews, performance appraisals. We've talked about those in the past on the program. We will touch on that in a little bit. But I want to talk about improper employment documentation. And really what you need to be thinking about is employment documentation. The goal of it really is ultimately to help you as the employer, number one, manage the employees' expectations and the company's expectations. Ultimately, at the end of the day, you're in business, your company is in business to make a profit for the most part, or if you're nonprofit, to make a difference, a result, achieve a result. And you do that through managing your employees and developing your employees. And so good documentation does help develop the employees. And if you have a poor performing employee, it helps you manage that employee out of the organization or to improve, either one. But the documentation helps you with all of that. So it's very important that you think about that through all of your documentation. The other
Now,
question,
Burt, I know I've asked you this in the past, as an attorney, when you get called and you're then going to help someone and you ask to see documentation, do you prefer that they're going to have more documentation or less documentation?
that's a little bit of a loaded question.
So
I
it
prefer,
depends.
it depends. I prefer that they have good documentation. And if the documentation's good, I prefer that they have plenty of it. If they have poor documentation, the documentation in and of itself is not of good quality, the more of that they have, the worse the case is going to be.
Yeah.
So, so yes, it's a big, huge, it depends. And so how does an employer get sued? And if Nick, if you can, pull up the next slide here, we all know that if any employee is in a protected category, and I put the bulk of them up on the screen there for you, if an employee falls into any one of these protected categories, the employee has a potential claim against the employer. And so you want to make sure that your documentation is in good shape, and it actually helps you try to avoid a claim of discrimination, harassment, or retaliation. And it doesn't actually contribute to the claim itself. So that gets to your question, Phil. Do I prefer that they have a lot of documentation or a little? It depends. It depends on the quality of the documentation. And I think that's what we want to talk about a little bit today. So,
well, when you put up that last one, and I think about the case you were talking about on Lawyer on the Clock, I could see, where that starts to get a little sticky, and the decisions made at Southwest Airlines definitely came out there around religious freedoms.
Yep.
And how to interpret those is going to be the difficult part.
Yeah, if I were Southwest Airlines, I probably would have taken a stab at, and maybe they did this in the case, I probably would have taken a stab at trying to counsel the employee from the perspective of having respectful dialogue versus calling somebody despicable and so on and so forth. I would have looked at whether the activity was done on company time or not on company time. But I probably would not have fired the employee if it was on the employee's personal time and not using the company's systems. I would have to dig into the facts of the case to make that determination. But again, tough issues to deal with.
Yeah, for sure. Okay, I don't want to sidetrack you there too much.
Sure. No problem. I know the audience likes our interaction here. So, getting back to the objectives of proper documentation, there's really several objectives to having proper documentation. And I think that this is where things really start to hit home. First of all, it puts the company in the best position to tell a story through its documentation. This may end up being your outline many years down the road when your decisions are questioned. And there is something just inherently reliable about good contemporaneously prepared documentation. That's documentation that's prepared at the time of the incident. And the reason why it's inherently reliable to judges and juries is because that documentation is prepared at a time that the employer, neither the employee nor the employer are contemplating litigation. So it's deemed to just be a little bit more trustworthy than testimony at the time the dispute is actually being litigated in front of a judge or a jury. So I
Yeah,
think
that
that's
makes
really
sense.
important.
That is critically important. Yeah.
Yep.
Burt, any reason for any of that to come through the request of an attorney?
So what, the actual employment documentation?
Yeah, so they go out and document this and this, and you're trying to protect it. You get called, hey, there's a problem. You're like, well, go investigate, create your documentation or trail. When is it good for that to come through the request of an attorney so that it's protected?
Yeah, so it's very interesting. That's a great question, Phil, because you can't use the documentation in court as both a sword and a shield. So what I mean by that is that you can't assert attorney-client privilege. You can't, first of all, claim you did an investigation and use the fact that you did an investigation to protect the company, to use it as a shield. Or actually really to almost use it as a sword at that point, and then say, well, we're not going to share the results of the investigation with you. We're not going to share what we learned because that's protected by attorney-client privilege.
Got
So
it.
what I'm getting at there is that you as an HR professional may involve an attorney sort of behind the scenes to help structure the investigation, even review documentation. But ultimately, at the end of the investigation itself, you want it to be public because that's going to be your defense down the road. Not just the fact you investigated, but everything that you learned during the investigation and how that supports your decision. So while there may be certain aspects of the investigation behind the scenes that are attorney-client privilege, the results of the investigation itself, any witness interviews, anything like that, that's all going to be fair game for disclosure down the road.
Got it.
Okay, so moving on to just a little bit further, there are reasons that documentation, like I said, is really important in this area. Whether an employee performs well or poorly, timely and accurate documentation really does establish a written track record for that employee. Documentation also helps the manager answer key questions, such as, which employee is best qualified for the promotion? What's the appropriate salary increase, if any? What's the appropriate discipline? What steps can help an employee meet or exceed performance expectations? So you want to make sure that you have your documentation properly focused to help support decisions that you as the employer make. And if you don't have good documentation, your decisions down the road may be subject to challenge by an employee or yet another employee who says, well, that person got a raise, I didn't get a raise, and you don't have any justification for providing that raise. You are going to be much better off if your justification is in writing at the time of the raise versus trying to explain a justification to a judge or a jury 3 or 4 years after the fact.
Absolutely. Yeah. That's so sometimes, Burt, when I think of this, I know we're up against a time. So there's documentation and investigation, and sometimes you're documenting events, but it's in form of an investigation. Just how deep of an investigation are you going to have? And one common problem, believe it or not, that I do see is people will investigate and document everything other than maybe the person they're having the issue with. They talk to everybody else and document everything everyone else says, make a decision without talking to the individual, maybe that allegedly had done something or is complaining about something, or they didn't sit and give that person an opportunity to explain themselves. I would always suggest in that is there's a starting point, and somewhere early on, you want to start with that person to understand where that investigation should take you. Is that a challenge at all when you get into a legal battle as to when or where that person was eventually chatted with?
Yeah, I don't see that too often, Phil. I mean, I think that, the Civil Rights Act has been around since 1964. Employers have had close to 60 years of this law and been able to figure out the best way to handle these investigations. And to me, every single investigation obviously starts with the person who's making the complaint. You want to get the complaint in detail, preferably in the employee's own writing if you can. And then the next step after that is to talk to, usually 99% of the time, is to talk to the person who's been accused of the wrongdoing and get their side of the story. And we always have to remember there's two sides to every story. We as the employer should not rush to judgment on anything, because you can have consequences for believing one side versus the other side in any of these disputes.
We'd be lucky if there's only two sides to the story.
And that's exactly right. I think the most important thing you can do when talking to the person making the complaint is try to determine and lock them down at that time as to who the universe of potential witnesses are to the potential misconduct. And so after you talk to the complainant, you talk to the person who's been accused, and you sort of figure out who the universe of witnesses is, then you start to focus in on who can support or perhaps support one side or the other in the particular dispute. And typically, once you do that, you as the employer then can have the weight of the evidence on your side when making an employment decision. The toughest ones, obviously, are when it's he said, she said, and there are no witnesses.
Absolutely. All right, Burt, we're going to wrap things up. I'm going to let you close out on your last slide or two here, and we'll call it a program.
Yeah, so just real quickly, some real world performance appraisals. Some of these, not all of these, are bad ideas. It kind of gets to what we were talking about in Philburt's Phorum. And I'm not going to go through all of these, but some of these get to that code that we were talking about there. Nick, you can kind of fast forward through these, but some of what we see in performance reviews that may be interpreted by a plaintiff's attorney in a little bit different way. I don't mean to say that none of these should be used in performance reviews. Just always take time to think how compliments or criticism might be construed by a plaintiff's attorney down the road if you're being sued. One thing I do want to mention real quickly before we hop off the program, just to kind of bail Nick out, who did our very nice lead-in intro, is Microsoft has its first union at one of its gaming production facilities, and that union is seeking to expand. We've been talking about unionization quite a bit on the program during 2022, and Microsoft has its first union, and just again, employers beware.
Yeah, absolutely. There you go. The unions are definitely out on the prowl. We got to keep our eye on for that. We must keep our supervisors informed and keep our ear to the ground and make sure we're watching for all the signs of that. Performance appraisals and documentations, very difficult to get right. I see comments in here by Julie. It seems like she's got a great system that she's building within her HRS that creates standardized questions to help lead that process. Wonderful idea. Thanks for those comments, Julie. I want to remind everyone, December 16th is the Right to Weed program. We are going to have a really good time with that program as well. Take it very serious and bring you the information you need to help manage your workplace. Burt, myself, and State Highway Patrolman Officer Jenkins will be with us, and we will help inform and answer your questions. With that, Burt, thank you very much. We will be back on air. Is it next week? I think we have our Washington Insider. Is that correct?
We're trying to line him up.
All right. We're going to talk about from lame duck to new paddlers if we can. Please join us then. We'll see you, and go out and be good to people. Thank you. Bye-bye.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.